All right, happy Friday, everyone. Welcome to the Legal Support Center for Advocates presentation, Rental Arrears Assistance Programs, presented by our supervising attorney, John Batanchef, and public benefits law graduate, Jacob Mortensen. So thanks everyone for joining us on this Friday afternoon. So just a little bit of housekeeping before we get started. If you could just make sure you keep your microphone muted, that way we don't have any background noise. If you do have questions, we will be addressing that at the end of the presentation, but feel free to put the questions into the chat and then we will address them at the end of the presentation. We'll have a few polls throughout and we will have a survey at the end. So if you don't mind participating in that, we'd really appreciate it. And I did send out the presentation this morning. So if you did not receive that, you can send me an email. I'll put that in the chat later. But I always send out the presentation again. Probably not today, but probably next week I'll send it out again. Just a little bit about Legal Services of Long Island. If you're unfamiliar, we are Long Island's largest provider of civil legal services that are for free. We handle over 6,000 legal cases every year. We provide direct representation, phone consultations, brief service or referrals to other agencies. We have offices in Hempstead, Islandia, and Riverhead. And our case handling staff include attorneys, paralegals, and social workers. And we do have partnerships with community agencies such as Brighter Tomorrows or The Retreat or Empire Justice Center. So we work with a lot of other organizations. And all of our services are free to those who are eligible. These are our different office locations and their phone numbers. If you have a client you need to make a referral to, please make sure you give them the phone number for the county that they are in. And we have about 20 different programs throughout the island. Our family specialized units are mostly in Suffolk County. We have domestic violence project or child support defense project. We have multitude of disability and health related units, whether it be mental health, legal care project, or our education and disability rights project. We have housing units in both counties, whether it's civil unit, which is eviction prevention, that's what it focuses on, or for foreclosure prevention project. We have other different units that may specialize in different areas of law, like our consumer debt project or education debt consumer advocate project, which focuses on student loans. Also veterans' rights, focusing on different individuals on Long Island, whether it's veterans, our adult care facility project. So a multitude of different projects. If you would like to have a further description of those projects, we do have a website which describes all of the different programs. And we do have a Learn About Legal Services of Long Island, focusing on all of the units on our YouTube channel. And we have our Legal Support Center for Advocates, which is specifically for advocates like you, whether you are a church volunteer or another attorney, a law student, a social worker, and a different nonprofit, anyone who is helping out a client who has a question on whether or not we would be able to provide services for that client or just has a question, a legal question that perhaps we can answer, please give us a call. Kathy Lucidi is with us today. She's just going to wave today. We have a lot of background noise going on in our office this morning, so that's why she's not going to introduce herself. But you know, we have Kathy, Hannah Fitzpatrick, who also you can call. We do host community trainings like we're doing today, where you might come to your organization. We publish newsletters. We have monthly legal lessons that we send out. I just sent out one this morning that gives some tips for you all. Okay, so the first poll that we're going to do is what type of advocate are you and have you ever called LSCA? So let me just grab those polls. I'm on a different computer today, so I might be a little slower. So first we're going to launch what type of advocate are you? So if you don't mind just taking a brief moment to answer the question, I'd really appreciate it. Okay, we have about 81% participating. So just another few seconds. Okay, I'm going to end the poll. I'll share the results. Okay, so it looks like we have a lot of social workers with us today, some attorneys, nonprofit employees, government agency employees, church volunteers, some self-advocates. So thanks so much for joining us today. Really appreciate you being here. And let's see, our next question is going to be, have you ever called the Legal Support Center for Advocates? If you just take a quick moment to answer that question, I'd really appreciate it. Okay, a few more seconds. Okay, I'm going to end the poll and share the results. Okay, so it sounds like a good majority of you have never heard of the Legal Support Center for Advocates. So really happy that you're here today. Please feel free to give us a call if you ever have any questions. If you are directly referring a client, please make sure to send the client directly to the phone number because Kathy, myself, and Hannah are not case managers, and it will take the client a lot longer to get what they need if they're calling us. So sometimes we have advocates who give our phone numbers, but unfortunately that's it just takes a lot longer for the client to get services. So advocates, we are so happy that you're here. Please feel free to give us a call and learn about what we do for you. Okay. So also definitely check out our website. We have lots of information on there, whether it be self-help resources or past legal lessons and newsletters, any upcoming events we have, all about our programs. So definitely check out our website. And just briefly, little announcement about next week's training. We're having latest student loan updates on January 22nd at 12 o'clock. So feel free to sign up for that as well. I know a lot of us have student loans, or our kids have student loans, or maybe we have friends who have student loans. I know myself, I'm finishing up my student loans through the public service. I can't even say it, the PSLF. The Public Service Loan Forgiveness Program. So it's always beneficial to know about what's going on, how to make sure that you're getting the most out of your student loans. So feel free to sign up for that. And just a brief note that, the information that we're providing today is legal information. It is not legal advice. Legal advice does depend on the specific facts of each situation. And of course, we always try to keep our information up to date as much as we can, but the materials that we're providing today cannot replace the advice of competent legal counsel. So always keep that in mind. Okay, and with that, I'm going to pass it off to John and Jacob.
Thank you, Sharon. My name is John Batanchev, supervising attorney for Legal Services of Long Island. I work out of our Hempstead office, covering our Nassau County clients. I supervise 4 of our units in the Hempstead office. Our public benefits unit, which primarily deals with issues with DSS and unemployment benefits, as well as Veterans Rights Project, our Mental Health Law Project, and our Human Rights Project.
And hi, everybody. My name is Jacob Mortensen. I'm a law graduate with the Public Benefits Unit in the Hempstead office. I've been here for about a year, and I'm going to be kicking us off today. So I guess we can get started. So when you're looking to get this assistance with rental arrears, the first thing you have to do is go down to DSS and apply. So when you apply for one of these emergency applications, they are generally required to give a same-day interview with a response in writing. That's their LDSS 2921 application form. And the application needs to be made by somebody, person in person, or through a designated representative. Generally speaking, you shouldn't be trying to apply online or through email or over the phone for this. Now, a few things that are important to note here. They are generally required to give a same-day interview, but if you show up, an hour before close, generally they're not going to see you. So you want to advise clients to get there as early as possible. A lot of social services districts are pretty understaffed, so there will be a bit of a wait. But it's just how it has to be to process the application same day, unfortunately. It's also very important that you advise clients to get their written response from social services, especially if it's a denial, so you can see the reason and see if there's reason to challenge it. Often, clients will know if they're told no, they'll get frustrated and leave, or the social services district just won't generate the notice. So it's important to advise clients not to leave without that written denial. Next slide, please. So DSS has a charge to prevent homelessness. If an applicant or a recipient of public assistance is facing eviction or foreclosure, DSS needs to intervene as soon as possible. Clients are often told that they need to wait until they have an actual notice of eviction or foreclosure. That's not actually true. All they really need is that if the landlord or the mortgage holder expresses, either written or in writing, or either written or orally, that they are planning to start a legal eviction or foreclosure, DSS needs to start doing something to prevent the eviction if the applicant is eligible for programs. Generally, if it is oral, you may want to get it in writing down the line, because if someone comes to DSS and just says, I was told, I have an eviction proceeding or foreclosure proceeding imminent, they may not want to believe the client, so written is best. Next slide, please. So the programs we're going to talk about later each have slightly different requirements and eligibility, but in general, you're going to need to demonstrate a threatened eviction. That's why I was talking about not, getting it just orally. So usually that's a letter from a landlord, court papers. You need to tell DSS how much you owe, so they know how much you're asking for. That's either with letter from the landlord or mortgage holder, a rent ledger, or a stipulation from housing court. You need to demonstrate the ongoing ability to pay rent. Generally, that's done through showing in pay stub, their Social Security award letters, and sometimes you also just demonstrate, the amount of money the client has when whatever checking or savings accounts they have. And this is important. The current month's rent isn't supposed to be included in the amount owed and the amount you're applying for, unless it's already overdue, and it is part of what needs to be paid to avoid eviction. Next slide, please. So let's talk about the grants. So there's three main grants social services uses here. There's the Emergency Assistance to Adults Grant, or EAA, Emergency Assistance to Families, EAF, or an Emergency Safety Net Assistance, ESNA. Now, it's important to know that you don't already need to be getting assistance from DSS to get an emergency grant. Oftentimes, it's a smart idea to apply at the same time, because if you're in a situation where you might be eligible for their benefits, but it's not required. Next slide, please. So the first one, ESNA, so Emergency Safety Net Assistance. So who's eligible? Single adults and childless couples, or households with a dependent child, or a household with a Social Security disability member. If the household is ineligible for EAF or EAA, which we'll talk about later. The emergency is defined as a serious occurrence or situation needing prompt action. The definition of emergency is different for all three grants, and they change pretty significantly. So it's important to keep in mind, why they're asking for this money, what happened when you're considering which grants your client might be eligible for. The income limit is 125% of the federal poverty level. There are exceptions if the emergency is because of a fire, flood, natural disaster, or if it's a heat or utility related issue. So, if the lights getting turned off. The rental arrear payment limit, so if you're asking for it for rent, is limited to a total of 6 months of rent in a 5-year period. and you do have to repay. Usually the repayment plans are within a 12-month period, and you can only get future assistance if your repayment plan is current. Now, immigrants who meet the cash safety assistance net requirements are also eligible for ESNA. Next slide, please. Next, we have EAF, or Emergency Assistance to Families. Households with children under the age of 18 or 19, if they're full-time students, are eligible. Facing an emergency from a sudden occurrence or unforeseen crisis that was beyond the applicant's control that demands immediate attention. You can see already the definition of emergency between these two programs is different. At a higher income limit, 200% of the federal poverty line. And just like the other program, assistance is generally limited to 6 months worth of rent over a 5-year period.
Jacob, I just
How-
just add that just because some people may not know, like put in context what those percentages are for the federal poverty level. So 200% of the federal poverty level for a family of 4 as of last year was about a little over $62,000 for a family of 4. It's gonna be more for 2025. I don't have the numbers for 2025, but just to kind of give you an idea what that looks like. But a family of 4 for 125% is 39,000 as of last year. So those numbers are going to change, but this gives you an idea of like what level of income your client has to meet to be able to be eligible for either of these programs.
Right. And that's usually available on several different government websites. You can find the up-to-date poverty level. So just like the last program, assistance is limited to 6 months worth of rent in a 5-year period. Households are responsible for repaying the amount above the cash assistance shelter maximum, which also is available online. So they aren't responsible to pay back the entire grant. And again, immigrants who meet the cash assistance temporary assistance for any family requirements of TANF are also eligible for this program. Next slide, please. And this is the last program that DSS usually handles, and that's Emergency Assistance to Adults, or EAA. So to be eligible for this program, you need to be 65 or older, blind or disabled, or be a couple who are eligible for or receive SSI benefits. So this emergency needs to endanger the health, safety, or welfare of an aged, blind, or disabled individual or couple. So again, another different definition of what kind of emergency applies. You need to meet the financial eligibility criteria for the SSI program. This program only allows up to 4 months of arrears to be paid, but the assistance is limited once in a 12-month period, unless individual circumstances require something additional. So it's a lot more. This program can be used much more frequently. There's no need to exhaust allowable resources. You don't need to, show that you've used everything of yours you can to meet the need, and no repayment is required. Next slide, please. So there are some differences in how PA applicants versus PA recipients have to deal with repayment specifically. So for PA applicants, so those who are in the process of getting cash assistance and other benefits, assistance can exceed the maximum shelter share allowance, but the excess is recoverable as an overpayment. So they'll give you more than the shelter share allowance, which again is the exact number based on your individual circumstances. Is available online and does vary from county to county. But they will take some of your benefits down the line if you're approved as an overpayment. So they'll take a chunk out each month going forward. For PA recipients, you have to agree to restrict future shelter allowances. That means that the amount of money for your shelter allowance will be paid directly to the landlord or whatever your situation is and not be given to you as a cash benefit. Assistance is limited to 6 months once every 5 years, unless DSS determines individual circumstances warrant an additional payment. And finally, duplicate payments are recouped from future grants, so there is no repayment agreement. Next slide, please. So we've talked a lot about the specific rigid requirements for each of these programs, but they do have exceptions. So DSS can issue a grant for an eligible household when the case is compelling. There isn't a definition of expectation or exception to policy given, but each district is told that they can develop their own exceptions and their own policy when they will give an exception. But generally, this would mean that there's some kind of extraordinary circumstance that led to the emergency, something that just nobody could have foreseen happening. The monthly rent is low, for example, a Section 8 voucher tenant, or the convenience of the apartment location, for work, school, medical activities, childcare are particularly good and are very valuable, or if there is a special needs child. Now, this isn't the sort of thing that social services tends to give on its own. It usually requires pretty strong advocacy in the form of letters and things like that. Next slide, please.
Great. All right. Thank you, Jacob. I'll be taking over from here. So as Jacob said, with the exceptions to policy arguments, there does require advocacy on the client's behalf. And so that's really a key thing throughout, even if you're not asking for an exception to policy, advocacy on the client's behalf is really important because oftentimes DSS will put on a denial notice something that is not correct, and we will have to fight to get that corrected. So I suggest if you know that a client will have an issue with meeting the eligibility criteria for one of those 3 grant programs, it would be best if you can write an advocacy letter ahead of time asking for an exception to policy, especially if it's revolving around. There is no exception to policy on the income limit, but we have a lot more success with the exception to policy on the monthly rental assistance limit of 6 months or 4 months, or if it's within a 5-year or 12-month period. That's where I think you can have a little bit more impact for a client, especially if they're on if they have a subsidized housing payment. It could make the argument that it's more cost effective for DSS to pay, even if it's 12 months of arrears, but it's $5,000 is a lot cheaper than for the next 12 months the cost of housing that family for DSS. So and it's obviously there's discretion at DSS's part on those decisions, but it's really important if you know those things are going to be an issue to address those at the front end as much as possible to try and increase your client's chances to get approved. So but if your client does get a denial letter, or if you believe that you're going to need to do more advocacy before that denial letter is issued, reaching out to the center manager or screening supervisor is really key. And this doesn't apply just to the emergency housing grants, but just in general with DSS, I think having good relationships with the caseworkers, with the supervisors at DSS as much as possible will really help when you need them to look over a case and figure out whether something was done incorrectly at the appointment level. And so trying to speak to those supervisors, making them aware of what might be those obvious mistakes that the front desk staff may have made is really important. If you feel like you're not getting anywhere with that, the commissioners have a response unit. You can call those numbers and try and advocate on their behalf, on the client's behalf at those locations. And if time is an issue, you can certainly arrange for an interim assistance with like a charity, which we'll go over later on about some charities that we are aware of that provide rental assistance, rental arrear assistance. A lot of those charities though it's a very limited amount of money and not always paying the full amount of arrears. So, but we'll go into that in a later slide. Next slide, please. So as Jacob mentioned, they're required to give a denial notice. So if your client is told verbally that they're being denied, instruct them to make sure they stay and wait for that denial notice. It should be given to them if they're determining that they're going to be denied. Sometimes DSS case workers will say it'll be mailed to you. They really should demand that it be given to them that day. I know at least in Nassau County, they claim that they're very short-staffed and are not able to issue those notices, but really you want to make sure that your clients ask for it, and if they don't get it, to ask for a supervisor to try and get those, because once you have that, then we can actually figure out what on paper what DSS is claiming is the reason for the denial. And once we have that, we've kind of locked them in. They can't kind of wishy-wash about why it is that they denied them. But even if they don't have a denial notice and they're told verbally there's a denial and there's no record at DSS of that denial, but there's at least the denial notice hasn't been generated, the case comment suggests that there was a denial, you can still request a fair hearing, but and you would want to request an expedited fair hearing. And usually the statute of limitations for those are 60 days from the denial to, so you really want to make sure you want to advise your client if they are going to challenge the denial notice that they request a fair hearing within those 60 days and to request it as an expedited fair hearing. Next slide, please. So there's a few ways you can request a fair hearing with DSS. There is an online request form, which is what I prefer. It's a little bit more legwork for the client or for the advocate to put in, but I feel like it's a really good way because you can get a notification that it's been received and that it's being processed. So that's a good thing for an advocate to know that everything is on track. There's also the telephone method. There's also mail, which there is a specific form on OTDA's website, the New York State Office of Temporary and Disability Assistance. They have a form on there. If you look up request a fair hearing, it'll have that information, and it has it all different languages too. So if your client speaks a different language, they have the forms in all necessary languages for the client. And then there's a way to fax it to OTDA as well. And these requests are not sent to the local DSS office, they're sent to OTDA. So OTDA processes these requests and schedules the hearings. And and usually because they're emergency applications, they should be held relatively soon, usually a few weeks to a month, potentially, depending on like the backlog. But that's generally how it works. Next slide, please. So another rentals arrear assistance program that DSS is processing or will be processing, at least locally, is this New York State Shelter Arrears Eviction Forestallment Program, the SAEF or SAFE program. It was announced late last year, I believe in October. OTDA issued both Nassau and Suffolk County money. I believe Nassau County was awarded somewhere around $500,000. I don't know the exact number for Suffolk, but it was probably around that amount. So these are not significant volumes of money, but they're something that are intended to be an add-on if someone is not eligible for one of those three other grant programs that DSS runs. So the basic criteria for it, or the basic information about it, is that it allows up to 6 months of assistance per household. And it does not have to be consecutive or paid all at once. And prior DSS rental arrear assistance in the last 5 years does not impact a SAFE eligibility application. The client does not need to be current on a one-shot repayment agreement with DSS. There is a separate denial notice and appeal process than the one-shot deal denial. So there isn't a fair hearing, but there is an internal process for clients to appeal with their local DSS office. The funds are supposed to be spent by September 30th, 2025. So DSS does have until the end of September to use these funds. But like I said before, Nassau and Suffolk County both have been awarded this money. I believe right now Nassau has not started up its program yet. They're anticipating doing it soon, but it hasn't been formally announced. I don't believe Suffolk has started it yet as well, but probably in the next few months, you will probably start to see forms and maybe references to this program. And once we learn that these programs are live with the local DSS offices, we'll try and make sure that we let you guys know that. We'll stay tuned on this program, and the next slide will go over more details on the eligibility for it. All right, so the criteria for this program is that you must apply for rental assistance through EAF or ESNA and be ineligible. For clients that would be applying for EAA, typically what DSS does is if they're denied for EAA, they will then run them through either EAF or ESNA. So one way or the other, those clients that are blind, disabled, or seniors that are applying through that program should then be funneled through, determine whether they're eligible for EF or ESNA. And that way, then they'll be, once the local districts are running this program, they'll then run them through the eligibility for this program. The client must meet same public assistance citizenship and non-citizenship status eligibility requirements. The eligibility criteria is similar to what it is for EAF, which is 200% of the federal poverty level, or under ESNA, it's 125% of the federal poverty level. One of the differences with this program is that the assistance has to either prevent or delay eviction, which is a little bit different than what the other grants are. Those ones, DSS is required to have to prove that they actually stop the eviction. Paying this money is going to stop the eviction. Here, delay is actually enough for this program. So unclear exactly what that means. Could that mean that they would just pay a portion of the arrears and the client would then work out a settlement to pay the remaining balance with the landlord through, landlord-tenant court stipulation? Or would that be where they would pay a portion of it before eviction proceedings have officially started, to kind of give the tenant more time? That may be more something that the local districts are going to answer and determine what they feel means delay. But that's something to be aware of, that is one big difference between this program than the others. The other thing is that the emergency can be one that was foreseen. So that opens up possibilities where if a client is denied because the DSS is claiming there was no emergency, or they don't meet the emergency criteria for one of those other 3 grants, they might be able to qualify under SAFE. So that's another key difference. Another difference is there's no repayment requirement unless there's fraud or the client is later found to be ineligible for the program for some reason. So under EAA, there is no repayment requirement, but under EAF and ESNA, there is. So this is a difference in that program as well. And I think maybe the biggest difference, and maybe where we can get the most clients to get approved, is in the requirement for the client to be able to pay ongoing rent, which is usually one of the requirements that DSS has, that client usually has to provide proof of that month's current rent along to be able to qualify for that grant. Here, they're not going to need to prove that they have the ability to pay. So that could be where the delay part comes in, where we'll pay up to date, bring you up to date, but it might just kind of kick the can down the road a little bit for the client to try and figure out plan B, either finding new housing or increasing their income. So next slide, please. So yeah, so that was the SAFE program. I will make sure to let Sharon know when those programs go live in both Nassau and Suffolk County, so that way people can start asking their clients to make sure that they're applying for that program. And it should be an automatic thing. They at least in Nassau, what the commissioner has told me is that an application for one of the emergency grants is basically the same thing for that program, for the SAFE program. So there shouldn't be a separate application. But just so you know, we'll keep you posted once we hear more on that front. And another program that at least Nassau County runs, and Suffolk, its Family Service League, is the Emergency Solutions Grant, ESG. So Nassau County Office of Community Development handles the intake process for this grant, and it's done over the phone. In Suffolk, they have 2 locations, one in Islip and one in Brookhaven. The numbers are listed. It provides up to 6 months of rental arrears, as well as other financial assistance for tenants that meet the at-risk of homelessness criteria, which I'll go into a little bit more later. The assistance can be combined with DSS one-shot grant, but must bring the tenant current. So there have been times where we, as an office, have been able to get DSS to pay up to 6 months or 4 months or whatever it is that they will pay, and ESG will pay the other 6 months of arrears. And it is difficult. It does require a lot of involvement by the staff to get those two programs to kind of communicate and work together. But it is definitely a possible thing that you could get a client to do. So if a client is, got like, let's say 6 or 7 or 8 months of arrears, trying to get them both to be combined with this grant and DSS assistance would really be is definitely a possibility. To qualify for the grant, though, all individuals must be a citizen by birth, a naturalized citizen, or a national of the United States. And the next slide will go over the specific eligibility. Okay, so the income limit for this grant is 30% of AMI, which is different than the federal poverty level. I don't have the AMI chart in front of me, but it's sometimes typically more than the 125% federal poverty level. The client does not have the sufficient resources or support network to prevent being homeless is a criteria. And then they'd have to be defined as at risk of homelessness. And what that means is typically ESG will require that a 14-day sheriff notice has been served on the tenant. More advocacy could, if your client is pre 14-day sheriff notice, but is imminent or soon to be, you could work on advocacy to try and get that kind of waived or accept where they are right now for at risk of homelessness. But traditionally, they want 14-day sheriff notice, which is kind of at the last stage of the process, which you really don't want to be at that point with their client. But sometimes to be able to get the grant approved, you kind of potentially have to wait for your client sometimes to be at that point. So that's the ESG criteria. And you can go on the next slide, please. All right, so then, so your client's gone to DSS, they were denied, they've went to ESG, there's also a denial there. My recommendation for clients is usually at that point to get the written denial notice from DSS, provide it to nonprofit rental assistance programs. And these are private grants, so the requirements vary, and the availability of the funds also fluctuate throughout the year. Sometimes they can only pay 1 or 2 months, sometimes they can pay more. So it may not even be enough to bring your client current, but it is something you should be aware of. But all of them will require that the client has been first denied by DSS for them before they can assist. So we have the numbers for some of the agencies that we're aware of that have funds or have traditionally had programs. So the Salvation Army is one of them. St. Vincent de Paul Society is another, and Catholic Charities are the 3 main ones that we're familiar with. But there may be others that are out there. And obviously you can try and see through your social networks whether there are other small nonprofit or little groups that will assist clients. Sometimes there's these small groups of individuals that will provide very temporary assistance. So there's always other things out there, but these are more of the institutional programs that are out there. So it's for you to be aware of. And next slide, please. Yeah, so that concludes our presentation. So we've gone over all the options for rental arrear assistance with DSS, with ESG, and the nonprofit programs. So that concludes our presentation. I don't know if there's questions.
Thank you, John and Jacob. There's a few questions, so let me go through them. Okay, so this is just a general question, but does Legal Services of Long Island have income limits for the people that we help? And it really is unit specific. Some units have income guidelines, such as the Consumer Debt Project is 200% of the federal poverty level, but our civil unit, which assists with eviction prevention, is 80% of the average median income, which for a family of 4 is about $90,000. It's a little more than that now. But some units don't have any income guidelines, such as our foreclosure prevention project, or our student loan project, the education debt and consumer advocacy project. But obviously, like a foreclosure prevention, if someone's making we do have to prioritize also. We can't be necessarily representing someone who's making a ton of money and not represent someone who's not making any. So there are priorities that put into place, but it really just depends on the unit.
Yeah, and Sharon, I can just, because so if a client of yours it needs assistance with obtaining benefits from DSS, typically they'll be working with our public benefits unit unless they qualify for a specialized unit. So the income limit for public benefits for both Nassau and Suffolk is 200% of the federal poverty level. Our Veterans Rights Project traditionally does not have a income limit, though we try to stay within 200%. Our Mental Health Law Project also traditionally doesn't have an income limit, but we also try to stay within 200%. And I'm just trying to think of, yes, you mentioned our civil unit, our housing unit is 80% of AMI. So anyone that has a client that's facing eviction, if they meet within that criteria, we should be able to help them on if they're facing eviction on that front. And I don't remember, let's see, what's the other, Jacob, remind me.
Foreclosure prevention, I mean, this is about rent arrears, but foreclosure prevention as well. They're very flexible with the eligibility criteria, being that we're talking about housing. I just wanted to
Yeah.
add that piece in.
Yeah, I'm trying to
Yeah,
think.
whenever someone calls and let's say they're not eligible for one unit, we always try to see if they're eligible in a different unit. If we can put them in a different unit, we will try our best to.
Very proactive with that.
Yeah, and that's also another reason why it's important, if you're unsure if it's going to be a good referral, to call the Legal Support Center for Advocates, so that way we can talk to you more about it and see if it will be a good referral. Margaret, did you have a question about that? I see you have your hand raised. Margaret Cullen? Okay, so we'll move on. So Sherry says, we always tell callers to apply for rental assistance at DSS as their first step. But in your printout, there are many programs: DSS rental assistance, emergency grants, SAEF, ESG. Can we assume that DSS will guide applicants to whichever program fits their needs and are eligible for?
Well, the DSS should be, at least internally, they should be determining which program the client should be eligible for, or what program to put them under to see if they're eligible. I don't know. I mean, I've seen situations where they have directed clients to other programs, but I'm not sure if that's a uniform thing. It's not necessarily something that's on their denial notice. I don't think it's like a list of other sources where they can go, but I have seen them write other places where clients can go, but I think that kind of depends on the caseworker. But I think you're right. Always have the client go to DSS first, because usually that's the thing that is needed if they're going to apply for a private, like a nonprofit grant. They want that denial notice. So I think that's always probably the best thing, to send the client first to DSS.
Just wanted to add on real quick. Even within the program that DSS offers, I have seen situations where they will evaluate somebody's eligibility under the wrong program, maybe one with the wrong definition of emergency, or under different financial guidelines. So that's why it's always very important to make sure you get that written denial if a client is denied.
Thanks, Jacob. Okay, let's see here. So, also, I had mentioned in the chat that I'll work to get the average median income and federal poverty level charts to you all. So we'll work on that. Do you know, this is from Emily, do you know if any of these nonprofit programs will help those who are undocumented?
I am not sure what their internal policies are. So I'm not sure if they do or don't. Sorry about that. I don't know, Jacob, if you know from your experience?
No, I'm not sure, just because that generally our clients are documented, so I don't have to navigate that very often.
I think if someone's in emergency housing and one of the family members is undocumented, because these shelters are so full, I thought I read that they will entertain assistance with getting out of emergency housing and into permanent housing and helping with the supplement. I know I read that somewhere. So I don't I think it just has to be someone who's in the household, but the others are citizens. I'm gonna look at my email while we're on the training, because I'm pretty sure something came in like that.
Right. Yeah, some programs may have different requirements. So unfortunately. So Sherry asked, DSS rental assistance, page 14, must demonstrate ability to pay rent ongoing. What if callers currently unemployed but looking for another job? If no income, then no option for but eviction?
Unfortunately, yes, that's one of the big requirements that DSS has, is the ability to pay ongoing. Now that will change with the safe funds, but again, those funds, as I told you, aren't an infinite amount. They're a very specific amount for this year. I don't know if it's going to recur. So when the safe program does open up, if you have a client that doesn't have the ability to pay ongoing, definitely try and get them to put in their application for that, because that'd be their best shot to get approved, at least delay things until things can get a little bit better for them to make things work out. But unfortunately, DSS does require that ability to pay ongoing. They even require it so much that they want when they issue the funds, they want the client to also bring in that month's rent to show. Sometimes that's their way of proving that the client can pay ongoing. So if the client can come up with that current month's rent to show DSS they got the money, that may be enough. But there may be more analysis that DSS does for clients. But that is, unfortunately, it puts a client in a difficult position.
Thank you, John.
I just put something in the chat as well, Sharon, and this is for those coming out of emergency housing. There's flexibility. Not everyone has to be a citizen. Status doesn't matter. Immigration status doesn't matter.
Thank you, Kathy. From Ryan, did we cover one-shot deal? Can you provide more information on that and what it's used for?
Sure. So the three grants that we mentioned, the ESNA, the EAA, and the EAF are, as a whole, are what we consider the one-shot deal grants that DSS has. So that's what the one-shot deal grants. We're just talking today about the rental arrear portion, but there is also an ability for those grants to pay for utility utility arrears, I should say. It could pay for storage units. It could pay for furniture, for new housing, for brokers' fees, for moving costs, for new housing. So there are other components to those one-shot deal grants, but today we're just really talking about the rental arrear portion of it. So we did a training about I think it was a month ago, that was on emergency housing, and we covered some of those grants in that presentation. So you may want to take a look at that one to see get that information there.
Thanks, John. And that is on our website. And I send it out in my legal lessons every month, and also it's on our YouTube channel. So if you have a problem accessing it, just let me know and I'll send it to you directly. Cecilia, do you provide bilingual services for Spanish-speaking clients? And the answer is yes. We have all of our receptionists are bilingual, and we have many other staff members who are also bilingual in Spanish. And if there's a language that we don't have a staff person that's who speaks that language, then we will use either language line, or we have professional interpreters come to the office. Okay, Eric, what if the tenant is being evicted as a holdover tenant?
So with a holdover, it's different than a non-payment. The holdover, it doesn't matter whether the tenant is current with the rent. That the landlord has decided that they just don't want the tenant there, either for a stated reason in the notice or for an unstated reason. Um, Sometimes with that situation, the landlord is doing a holdover because they don't think the client's going to be able to pay their arrears, or because it's due to a lease violation that says that they have to pay the rent on time and they're not repeatedly not. So the landlord would bring a holdover to do that. So sometimes that may just require the landlord to have a letter written that says that if they're paid everything up to date, they will not continue the eviction, or that's a step, or it could be where the tenant is represented by an attorney, or they enter a step on their own in court that says they're converting the holdover to a non-payment and they have to pay this money. So there are options with a holdover, but traditionally, if the landlord really is just committed to getting them out, uh, payment by DSS, DSS is not going to view that as ability to prevent the eviction under their normal one-shot deal grants. They're going to see that as, well, we're not, even if we pay, the landlord's not going to stop the eviction. So they're not going to, they're most likely not going to approve it unless there's something from the landlord stating that they would stop if the money is paid. And that could be in the form of, like I said, a stipulation that says that it's being converted to a holdover, converted to a non-payment action, and that the landlord will accept the arrears by a certain date.
And make sure that if you do have a client who is being evicted for any reason, or just have them give us a call right away, so that way we can evaluate them and work to get them the assistance that they
Can I
need.
just add one thing, Sharon, as well? A lot of times with the holdovers, the longer they've been there, the more notice the landlord has to give. It's not like it used to be a 30-day notice. And we also could see what the lease says. But that's important to keep in mind too. Like, somebody who's been there for 3 years, or 2 years and up, they have to give 90 days notice. That's 3 months rather than it was back in 2018. And the amendments were changed in 2019. So keep that in mind too. Sometimes the landlords don't get it right, even in a holdover. And that's what our civil unit is for. So definitely call us. They're all over the courts, all the courts district courts in Suffolk and in Nassau County. So if you have anybody that's even started with a holdover, give us a call so we can check it out and see if we can assist them in some way.
Thank you, Kathy. Delicia says, can this help with late fees? The rent is up to date, however, there are late fees.
So in New York, based on what Kathy was saying about the changes to New York landlord tenant law in 2019, a landlord couldn't bring an eviction proceeding unless it's based off of, or I should say, a non-payment eviction proceeding, unless it was based off of rent. Late fees used to be part of the non-payment process, where they can include the late fees, they can include attorney fees. After June, I think, of 2019, the law changed, and non-payments have to be based off of rent. It cannot be based off of anything else other than rent. So if a landlord is bringing an action for non-payment against a tenant, and it includes late fees, it includes other non-rent charges, there's a good chance either potentially we could get that case dismissed, or we just settle it so that it's just limited to the rent arrears. And the late fees are something that the landlord's going to have to either eat, or they could, sue the tenant in a collection action for those late fees if they are or other non-rent fees if they choose to. But as far as eviction, it's got to be based off of rent, the non-payment action. So DSS knows that, and so if there are late fees, if the only reason that there's a threat of eviction is late fees, supposedly, DSS probably will not be paying late fees. They can only pay, because the late fees are not going to prevent the eviction. It's going to be the rent only. If the rent is paid up to date, the landlord has no case to bring a non-payment, and therefore there's no threat to evict the tenant.
Thank you, John. Okay, Lyda says if a disabled person over age 62 is on several Section 8 wait lists for several years and is homeless, can they get assistance to be given priority on the list? So I think we're going into a different area here, but I don't know. So I don't know if John and Jacob have the answer to that, because that might not be their specialty, but I'll ask them if they know.
So yeah, this program is geared towards when clients have housing and they're and they've fallen behind on the rent and need some sort of assistance to bring them current.
I think I can answer that
You
question.
want to try? Okay.
For Suffolk at least. I
Okay,
can't
that's
answer
good.
it for Nassau County residents. We find that there's really no way to move somebody up the Section 8 list. We've tried, our social workers work really hard, but there's really no way to move somebody up the Section 8 list. The only thing that I could say that's so important when it comes to being on that list, and it's unfortunate because it happens with a lot of our clients because they're moving from shelter to this, to here, to there. Keep notifying the Section 8 provider of where you have moved. That is one of the most important things when you're on that wait list. Go to the interview when they call you and they say you're up next. Keep calling them saying, where am I on that list? But definitely advise your clients. And it's a very stressful time. They may be bouncing from one place to another. They're sleeping on a sofa somewhere. They're going back into a shelter. They have to notify Section 8 where they are. But we've noticed that they don't give any preference to any situation and move people up the list. We've never seen them do that. That's in Suffolk County. I can't answer for Nassau County.
Okay.
So well, I guess it all depends on she's mentioning Section 8 wait lists, but there's different types of wait lists. There's public housing, there's project-based Section 8 wait lists, and other private rental wait lists as well. But I know for spa housing, for those that have a mental disability, there is supposed to be prioritization if one of those applicants is homeless. So I can speak to that there should be they should bump up on the list, I suppose, when they can notify them that they've become homeless or at least facing a risk of being homeless. And I guess to add on to Kathy's point with contacting whoever has the wait list that you've applied for, is to make sure that you if you can set up like a PO box or another location for mail to go to. Sometimes they'll send notifications of where you are in the process or ask for updated information. If it's been a few years, they need something updated. And if that mail comes back, then they sometimes won't even bother doing a phone call. They'll just take you right off the list, and you won't know until you call them up and ask what's going on with, where am I on the list? And they say, oh, we kicked you off 2 years ago because we got mail returned. So make sure if you do have an address, it's an address that they'll be able to, it'll be able to accept mail. And sometimes having just a PO box is helpful just to make sure nothing gets kicked back. Because I've seen that for clients that they've been kicked off because mail came back that it was not they were not there or not not able to be delivered. So that's like an important thing, because it as you all know, it takes a really long time to get approved and housed on those wait lists. So it'd be a shame for someone to lose their spot because mail just got returned.
And can I just add one more thing? I'm sorry, I know it's a rent arrears seminar, but Section 8, we at Legal Services of Long Island take Section 8 terminations very seriously. The sooner you know that something might be that the client's in jeopardy of losing their Section 8, that's when you have to call us, because that's when we start building a paper trail. And we consider it a very big deal if somebody's losing their Section 8 voucher. So always get in touch with us if you have clients that already have Section 8 and they're maybe in jeopardy of losing their Section 8 voucher. The sooner, the better. I can't stress that enough.
Thank you. All right, so there's like another 1 or 2 questions about or experiences. But we're out of time now. So if there's any other questions, I'll address them via email. So thanks so much, everyone, for coming today. It was a great presentation. Thank you, John and Jacob, and thank you for all of your questions. Just a reminder, next week we have the latest student loan updates presentation, so definitely sign up for that and check out our website. And if you are interested in getting these, alerts on when rental assistance is opening, when Section 8 is opening, I just made an announcement this week that Section 8 in Huntington is open. It's actually open only until today. So if you have clients who are going to apply, make sure they apply today. But we do send those alerts on Facebook, Instagram, LinkedIn. So follow us. Make sure you sign up for our legal lessons so that we can get the word on what's going on. All right. And thanks so much, everyone, and have a great weekend.